All right. Well, welcome everyone to our webinar on the new aged care reforms, what your business needs to know. So my name's Stephanie Long. I'm a senior lawyer in our commercial and regulatory team here at LegalVision, and I'm joined by my co-host Ushna, who's also a senior lawyer in that team. We work really closely together and we're excited to join you today to talk about this topic. Before we begin, just a couple of quick housekeeping items. So you'll receive the recording and slides of this presentation in your email following the presentation, so keep an eye out for those. You can feel free to submit your questions in the Q&A box and we'll answer them at the end. Please also take the time to complete the feedback survey after the webinar. It's really helpful for us to be able to hear from you what you enjoyed, what you want to hear more about, so that hopefully we can keep catering to your needs and providing good information for you.
Thank you, Steph. Yeah, lovely to, virtually meet all of you, though I can't see you yet. By viewing this webinar, you are eligible to receive a complimentary consultation with the team to discuss how we can help your business. And so to claim that consultation, leave your contact details in the survey that will appear once the webinar's ended. Or otherwise, if you missed that, you can always just contact us via our website and we would be more than happy to help. There now should be a poll question that's popped up on your page. I think this will be up for about 2 minutes, so take your time answering that and we can really quickly then go over the results in a moment. But the question is, how prepared is your organisation for the new aged care reforms? Options are, we've already adapted to the changes, which is great. Otherwise, we're in the process of implementing changes, also great. We haven't started yet, also fine, and not sure what changes apply to us. Well, that's why you're here. So all answers, no incorrect answers. Click whichever one applies to you, and then we will talk through that in a moment. In the meantime, we'll get Steph to go over the agenda for today.
Yeah, no worries. So what we're going to be talking about today during our time is a quick overview of the changes. Then we'll step into what the new workforce standards are. We'll go through what the aged care quality standards, how they've been updated and amended. We'll then talk about the new kind of support at home program and the reforms to home care. We'll touch on the governance requirements and how that impacts you as part of the key personnel of an organisation, if that's you. We'll talk a little bit about information sharing and privacy. We'll touch on restrictive practices and the changes to those as well. Then we'll just finish up with a couple of practical steps, some considerations that you can undertake, and then there'll be time for Q&A at the end. I note that we have received some pre-submitted questions, so hopefully we'll get time to talk about those as well as any that you submit live. As I say, you can pop them into that Q&A box when you're ready.
Okay, great. And we've now got the results. The results are in. Let's go through them. So 25% of you have said that you've already adapted to the changes. Amazing to hear. 25% of you have said that you haven't started yet. And 63% of you have said that you're here to learn and you don't know what changes apply to you, which is great. And hopefully that means that you'll get a lot out of today's session. All right, now we can jump right into it. And so Steph will start and provide us with an overview of the changes to expect.
Yeah, thanks, Ush, and thanks everyone for responding to that poll question. Hopefully we can give you a lot of value today. So as many of you would know, the new Aged Care Act is the legislative response to the findings of the Royal Commission into Aged Care Quality and Safety, which was run in 2021. Those changes and the new Aged Care Act is designed to create a person-centered system driven by respect, rights, and transparency. So as at the time of this webinar, we're expecting those reforms to commence from the 1st of November of this year, 2025. However, this date has already been pushed back once. It was originally 1st July, it's now 1st November, and the space is always changing. So we are, and hopefully you will be prepared to be able to make changes adaptively closer to the commencement of the new Act, whenever that might be. Now you'll see an image on the screen there about what some of those key changes are, placing the person and their rights at the centre, and then the other surrounding values that support that. The new focus is on enforcing high quality care through stronger aged care standards and the embedding of older people's rights, all of which will be legally enforceable as a result of a more proactive Aged Care Quality and Safety Commission. There will be increased public reporting requirements for providers regarding those quality indicators. There'll be greater restrictions around financial performance and governance structures as well. So there's also going to be some increased emphasis on responsibilities for workers and tighter requirements on who can work in aged care, which Ushna will now discuss.
Thanks, Steph. The reforms place a really strong emphasis on strengthening the aged care workforce to ensure that there's high quality and safe care being delivered. So some of the key aspects of the new workforce standards include the Code of Conduct for Aged Care. So this is the mandatory code that's already in effect, and it sets clear expectations for the conduct of all aged care workers and governing persons. It includes 8 fundamental behaviour statements, such as acting with respect for people's rights, treating people with dignity and respect, respecting privacy, acting with integrity, honesty and transparency, and promptly raising and acting on concerns about quality and safety. This ensures a consistent standard of professional conduct across the sector. The Code of Conduct is inherently linked to mandatory reporting requirements, as its principles directly underpin the requirements of the schemes, like the Serious Incident Response Scheme, which is further strengthened by the new changes. There is also enhanced worker screening. This is really important. So the amendments strengthen existing worker screening requirements. This involves more robust background checks for all aged care workers, including national police checks and, if applicable, NDIS worker screening checks as well. There's also an ongoing obligation for providers to regularly check the Aged Care Quality and Safety Commission banning order register to ensure that no prohibited individuals are being employed in your organisation. Continuous professional development and training. So specific mandated hours have not yet been fully detailed for all roles, but the reforms do signal a greater focus on ongoing training, skill development, and professional supervision for the workforce. And so really the aim of this is just to ensure that workers have the necessary capabilities to deliver high quality, person-centered care, especially in areas like dementia care, palliative care, and cultural safety. There is an increased focus on clinical governance, which includes ensuring the workforce is appropriately skilled, supervised and supported. And then finally, whistleblower protection. So the significant changes being brought into that place, and basically the definition has extended as to who can make a protected disclosure, including residents and staff. Anonymous reporting is allowed to various recipients, and it's provided stronger immunity from liability and protection against victimisation. It also mandates that aged care providers establish whistleblower systems and policies and train staff, aiming to really foster transparency and accountability across the sector.
Yeah, thanks, Hush. We'll touch now on the aged care quality standards, which have had a significant evolution with the new changes. So just for clarity, the aged care quality standards apply to the standard of services being delivered, whereas the Code of Conduct that Ushna was just mentioning places more of the emphasis on the standard of behaviour applicable to aged care workers. Back to the standards themselves, they were an existing structure introduced in 2019 and at the time comprising 8 standards. The Royal Commission, however, has found that their implementation often fell short, and they were often interpreted as simply a compliance checklist. So for that reason, we now have a new set of aged care quality standards. They are fewer in number, but they're greater in detail, ideally. We now have only 7 standards, but each standard is aiming to encompass more specific requirements. So for example, the previous standards included a section allowing for feedback from those receiving services. Now, it used to be the case that providers had to ensure that older people feel safe and encouraged, supported to be able to give their feedback and make complaints, that they're engaged in processes to address feedback and complaints, and that appropriate action is taken. That was the old standard. Now, the expectation is for all aged care recipients to be able to say, quote, "The organisation is well run. I can contribute to improvements in care and services. My provider and aged care workers listen and respond to my feedback and concerns. I receive funded aged care services from aged care workers who are knowledgeable, competent, capable, and caring." The new standards are also explicitly rights-based. Previously, it implied consumer-centred care, but now the new standards explicitly integrate and operationalise the Charter of Rights. The emphasis is also now less on processes and more on demonstrable outcomes for older people. So providers will need to show not just what they do, but the impact of their actions, which will necessitate fairly robust data collection and evidence-based practice. The new framework also places a greater emphasis on providers having systems for ongoing monitoring, evaluation, and continuous improvement, trying to move beyond that tick box approach. Now, there is some practical guidance available via the government's website. If you search for Draft Strengthened Quality Standards Guidance, you can then select from each of the new standards, and it will walk you through exactly what kind of steps you can take to comply with the new and improved standards.
Great, thanks, Steph. The current home care packages program and the Commonwealth Home Support Program are being reformed into a single integrated support at home program. And this is one of the most significant changes this time around. So the new program aims to simplify access to home care services by consolidating the two existing programs. This means a more streamlined system for older people to receive a wider range of services to support them to live independently and at home. There's a needs-based assessment now. So services will be determined by a single comprehensive assessment process that focuses on individuals' needs and goals rather than predefined package levels. And so what this means is that the care being delivered is a lot more tailored and flexible. There is a single assessment. So it's a single assessment system to streamline how older Australians access care. It replaces the previous fragmented assessment pathways with a single comprehensive evaluation. And the goal is really just to ensure that individuals only have to tell their story once and that they receive a consistent person-centered assessment, which we can clearly see is a common theme across the board. And, regardless of whether it's for in-home support, residential care, or other programs, and it means that we're able to adapt to their changing requirements without the need for multiple separate assessments. The program will continue to include support for care management, helping individuals navigate their care options and manage their services. There will be an increased emphasis placed on assistive technology and home modifications and providing access to this technology, for example, through mobility aids, just to ensure that there's safety and independence at home. There is a stronger focus on restorative care, hoping and the aim for that is really just to ensure that older people maintain or regain their independence and their functional abilities. And the funding model is really shifting to be more transparent and more flexible. So funds will be directly linked to the assessed needs of the individual, allowing for greater choice and control. And this is a move away from the current package-based funding that you're all probably familiar with.
Yeah, thanks, Ush. I'm sure many of you will be key personnel members within your business. So CEOs on the board of directors, you play a really core role as part of the provision of care in your organization. And the amendments now are placing an increased obligation on you in that role to be the driving force in promoting a rights-based culture and taking active steps to monitor, review, and continuously improve the quality and safety of care that's being delivered. So with that in mind, some practical steps that you could consider if you're in that position or you know someone who is. The main Couple of things are, you'll need to make sure that you're taking active steps to ensure the financial viability of the organisation, which is part of your ordinary obligations as a director of a business, whilst making sure that you're transparently using funds to deliver quality care. So how are funds being directed? Where is the emphasis being placed? You also want to make sure that you have adequate staffing levels, appropriate skill mixes, and a positive organisational culture that creates a strong workforce. So how's that being reflected in your policies and procedures with your employees? How is that being reflected in the training that your employees receive to be able to be up to speed on all of these changes and be able to deliver on the ground great and safe care? As well as that, there's an expectation that you're ensuring accessible, responsive, and transparent processes for managing feedback and complaints, which we've touched on earlier. So how easy is it for an older person to make a complaint? Is the system overly complicated? Is the tech really chunky? How can we make that process as smooth as possible and ensure that on the back end, we're responding to those issues? We'll also need to make sure that you're identifying, assessing, and mitigating your risks related to quality, safety, and financial performance. That's more of a general comment. A new emphasis is making sure that you're providing accurate and timely information to other members of the governing body and to the commission as appropriate. You also want to make sure that you stay abreast of all the legislative and regulatory requirements, which is part of what you're doing today by joining this webinar, is making sure that you're across the changes and familiar with how they impact your business. There's also an emphasis on requesting and critically reviewing all relevant information. So you're making sure that you're able to make those informed decisions about the quality and safety of the care that you deliver and the financial transparency of the business. So that will include things like audit reports, financial data, incident reports, patterns in the feedback and complaint that you might receive from individuals if you do receive them. And of course, yeah, those general financial statements. You also want to make sure that you establish robust policies and procedures for identifying, disclosing, and managing any perceived or actual conflicts of interest. Now, the penalties for non-compliance with governance standards can be substantial and reflect the seriousness with which these obligations are viewed. So those penalties can range from financial penalties, civil penalties, loss of approved provider status, disqualification of key personnel, and reputational damage. It's important to note, of course, that directors in their role may face personal liability for breaches of their duties, which can potentially expose their personal assets to claims. So this means that directors, if they fail in their directorial duties, can't always rely on the corporate structure or the removal from personal liability that might be prevalent in a proprietary limited system. You can't always rely on that if there's a failure to meet your governance obligations, and personal assets can be on the line. So it's really important to make sure we get this right.
Great, thanks, Steph. So I will now be discussing information sharing and privacy, which is a significant area of change within the aged care sector. And this is driven by the need for greater transparency, accountability, and effective use of data to be able to provide improved care. So there are enhanced information sharing powers between aged care providers, the Department of Health and Aged Care, the ACQSC, and other relevant government agencies, just to ensure that there's better oversight, improved regulatory responses. Regulatory oversight, well, essentially what this means is that it enables regulators to access necessary information for monitoring compliance, investigating incidents, and enforcing standards. Data-driven improvements. So, it supports the collection and analysis of de-identified data to inform policy development, identify areas of improvement, and enhance the overall quality of services. And the information sharing is critical for client outcomes. So it facilitates the sharing of relevant information to support care coordination, particularly when an older person is moving between different care settings or providers. There is a new statement of rights for older people receiving aged care, which includes an explicit right to privacy and the right to have personal information handled confidentially and securely, really strengthening an individual's control over their personal data. Of course, aged care providers remain subject to the Australian privacy principles and the Privacy Act. And the reforms really just reinforce the need for providers to have robust privacy policies and practices, ensuring personal and sensitive information is collected, used, and stored, and disclosed in accordance with legal requirements. There is a mandatory incident management system where providers are now legally required to have effective incident management systems in place. So this isn't really just about reporting, it's about having a comprehensive, proactive approach to identifying, recording, managing, resolving, and learning from all incidents that occur, and even near misses that might occur. And so the types of security incidents that have to be reported have also been significantly broadened. I think with these broader aged care reforms are supported by a digital transformation agenda, which will increasingly rely on, having secure and efficient electronic health records and information systems in place. This necessitates robust cybersecurity measures and clear protocols for data governance.
Thanks, Ush. It's now just a time for us to touch upon restrictive practices, which are well known to be a somewhat difficult area. It was already the case that restrictive practices should only be considered and implemented after all other non-restrictive alternatives have been explored and failed, and that a behaviour support plan should be in place to be able to govern the use of ongoing restrictive practices. However, the new Act will explicitly prohibit the use of restrictive practices that are not necessary to prevent the harm to individuals or others and are not used for the shortest amount of time possible. So with that comes a new reporting regime. That will be a kind of key area of compliance and transparency with the new Act. So providers are going to be required to report all instances of restrictive practice use. This includes even single uses, not just ongoing ones. You'll also be required to report the type and duration of the practice, the reason for its use, evidence of consent, the details of any alternative strategies that were attempted before turning to the restrictive practice, and all the measures that were taken to reduce or over time to cease the practice, ideally. So this data will need to be reported to the Commission, and it's expected that this will be used for monitoring, analysis, and potential public reporting to foster greater accountability and transparency with the public. The previous framework had some provisions regarding restrictive practices, of course. However, the new approach makes pretty clear that the use of restrictive practices not in accordance with what we've just discussed is prohibited and carries with it that greater regulation, reporting, scrutiny, and potential consequences. So in essence, the new framework shifts restrictive practices from a single care decision, often made at the facility level, to a more highly regulated intervention that requires significant justification, oversight, and ongoing review.
Thank you, Steph. Steph and I will now go through some practical steps that your organisation can take to implement the changes that we've discussed today. So from a culture and workforce transformation point of view, the first thing to think about is rights-based care training. So implementing mandatory comprehensive training for all your staff, whether that's clinical, care, allied health, admin, on the new Charter of Rights, what it means in practice and how to embed it in daily interactions. Restrictive practices training, which Steph just touched on. So provide specialist training on positive behaviour support, de-escalation techniques, and the new guidelines and reporting requirements for restrictive practices. Really emphasise the last resort principle with your staff. And then really important that you are reviewing and updating your HR policies. So, review your recruitment and onboarding processes to check that it aligns with the new screening requirements, including enhanced police checked and worker screening requirements, if applicable for NDIS. You should explicitly incorporate the aged care code of conduct into employment contracts, staff handbooks, performance reviews, and develop or update a clear policy for checking and acting on information from the ACQSC Banding Audits Register for all personnel, just to ensure that there's no one on there that you've hired You also want to review your existing subcontractor agreements to make sure they also comply with the new rules and that you do have a course of action in place against any subcontractors if they break the rules. So preparing for the support at home and home care reform. Obviously stay informed, which you are doing by joining this webinar. Actively monitor any official communications that come from the regulators, regarding the design and the implementation details of the program. Attend workshops, webinars, information sessions provided by government bodies or industry associations. Review your service delivery model. So assess your current service offerings under HCP and CHSP to identify how they align with the proposed integrated model, and develop a plan to transition existing clients and their care plans to the new program framework, focusing on that individual needs-based assessment rather than previous package levels. You should also update your financial and administrative systems. So prepare your systems for the new funding model, which will move away from the package-based funding. And, this might look different for every business, but it could require significant changes to invoicing, budgeting, reconciliation, and also review and update your service agreements with clients to reflect the new program's terms and funding arrangements. And then finally, with regards to information sharing and privacy, I did touch on this a little bit before, but, review and update your data governance policies. So your privacy policy, your data handling policy, information sharing agreements, just to ensure that they're complying with, obviously, the new Strengthened Act, but also your existing privacy obligations. And as a business, that's something you should be doing every 12 months anyway. Clearly define your protocols for secure information sharing with government bodies. Strengthen your data security. So really important to invest in, robust cybersecurity measures to protect client data and organizational data from unauthorized access. And so that might look like firewalls, encryption, regular backups, and secure access controls. You should implement clear policies for staff on secure password management. And so, making sure that they're changing their passwords regularly and not sticking to the standard business name. I know we've all been guilty of that before. Just ensure that you also have the appropriate insurances to cover any potential incidents that may occur. Train your staff on information handling, provide them with training on what their responsibilities are in regards to information sharing and privacy. Ensure that staff really understand when and how information can be shared, and also the importance of getting consent. And then finally, develop robust incident response plans. So establish and regularly test clear incident response plans for data breaches or security incidents, outlining immediate steps and notification protocols, and also remediation actions that you would take. And by taking these practical steps, your organization can really proactively adapt to the evolving aged care landscape, ensuring that you're complying and you're also providing enhanced service quality to your clients.
Thanks, Ush. A couple more from me. Something to consider is mapping your existing policies against the anticipated requirements of the new Act, the Charter of Rights, the Code of Conduct, and the Quality Standards. So this will help you to identify areas where policies might be absent, where they might be inadequate, or where they might need significant revision to align with this real rights-based approach, the new governance obligations, and the restrictive practices guidelines. As well as this, we're expecting greater guidance to come out in the coming months regarding service agreements that you'll need to update with the persons receiving care, which Ushna mentioned. It's the expectation that you'll need all new service agreements. So prepare for that update and keep an eye out for the guidance, as will we. As well as that, as part of assessing your current practices, don't just look at the policies that you have in the drawer, but observe the actual practices on the ground. Are staff truly implementing person-centered care? How are restrictive practices currently being managed? And how can you integrate that with the training that Ushna suggested to make sure that everybody's actually doing what we say we're going to do? As well as that, you might want to consider identifying the gaps in your data collection. So what data do you currently collect on quality, safety, any incidents, and the use of restrictive practices? Does it meet the anticipated new reporting requirements? Is it robust enough? Of course, don't hesitate to seek external advice from us at LegalVision, other governance experts, and perhaps clinical experts as needed, depending on the type of supports that you provide, to assist you with that gap analysis, policy development, and any training that you might need. As well as that, it's always helpful to stay vigilant and monitor for regulatory updates. There's constantly new guidance coming out that can help us have more practical perspective on what's going on, gradually being released by the Department of Health and Aged Care and also the Aged Care Quality and Safety Commission. So we're keeping our eye out for that, and we suggest that you do it too. Implementing these reforms is a pretty significant undertaking, and it can seem like there's a lot to do, but it's absolutely an opportunity to elevate the quality and safety of aged care in your business and across Australia. So by taking these practical steps now, your organisation can not only ensure compliance, but also build a truly rights-based, person-centred model of care that you can use into the future. And so that kind of concludes the main part of our webinar today. You might find our publication useful to be able to keep your learning about what we've spoken about today. That's the new Aged Care Reform's 6 Things to Know fact sheet, which you can download using that QR code or in the resources tab. We've also got another upcoming event that you might be interested in, which is asset sale versus share sales, what your business needs to know. So if that's on your agenda, if something you've been thinking about, you can always register and come along to that as well.
So we are going to answer your questions shortly. So if you have any questions, you can submit them now. And while you submit them, I'll just take a moment to tell you a little bit about how LegalVision works and our membership. And so the way that we work is a little bit different to other law firms. We operate on a membership-based structure. And once you become a member with us, your business really essentially gets unlimited access to our full team of 100 plus specialist lawyers for all of your business as usual legal need. It's really like having an in-house counsel, but you're paying a fraction of the cost. So our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, as well as unlimited domestic trademark registrations and a lot more. And so, the benefit of that is you won't really have to worry about the cost of lawyers again, because, we'll take care of your business as usual legal work, and then you can focus on running your business. And there's definitely a lot to do if you think about all the changes we've talked about today. If you are in-house counsel, we also offer a dedicated service to manage your high volume business as usual legal task. So yeah, look, if you're interested, and even if you just want to know a little bit more about how membership or desk extension for in-house can work and help you, just request a free consultation when the survey appears at the end of this webinar, and we'd be happy to provide you with some more information. Okay, great. So we will now go through the questions. So there were a few questions that have been submitted before, so we'll start with those. And then hopefully we've got time to jump through any that you guys have submitted now. But if not, like I said, you do have that consultation, so don't fret. I might just start us off, if that's okay. So the first question was about how retirement living is affected. So the Aged Care Act is primarily targeting government-funded aged care services. Retirement villages as a whole are generally regulated by state-based legislation, not Commonwealth Aged Care Act, which, if you're in that space, you probably already know that. The changes may indirectly affect retirement living though, but we generally don't advise on retirement living. It's not an area that we've got expertise in, but you should definitely expect there to be, at the very least, increased scrutiny and expectations, especially with the increased focus on consumer rights, consumer choice and dignity. So I think there will definitely be carry-on effects in the retirement space.
Yeah, absolutely. I've got another question coming in here at the moment, just saying, what is the responsibility of a care homeowner or manager to ensure TGA or FDA approval is correctly in place for the use of medical devices for residents, especially with bed-bound residents or wheelchair residents? This is a really great question. So if you as the care homeowner or the manager are procuring those goods for the resident on their behalf, you are responsible for ensuring that they're fit for use. And you are responsible for the quality and safety of the care for that individual. Now, the Australian Register of Therapeutic Goods, or the ARTG, is relatively easy to search, and it shows us all approved therapeutic goods in Australia. Now, FDA is the US system, and even if it's FDA approved, that doesn't necessarily mean that it's TGA approved or approved for use in Australia. So definitely make sure that you're checking it against the Australian standard to make sure that Australian residents are safe. Now, owners and managers must ensure that medical devices that are being used are used in accordance with their intended purpose. So that might involve making sure that your staff are up to speed on how the device gets used to make sure that it's not being used in a way that's unsafe. In addition, something to consider is the way that this might interact with incident reporting in general. So if there's an adverse event, which is a term used in that medical device space, but basically meaning something like an injury or a malfunction of the device, you need to report that to the TGA, and then this will interact with your other reporting requirements, which we've already spoken about during this webinar. So great question, and those are a couple of things for you to consider.
Great. So one of the other questions was, is there a price fee or cap for allied health providing home visits? Is it true we cannot charge travel and reports and only charge the face-to-face time? So yeah, this is a really crucial area of change, and it's a point of ongoing discussion for allied health professionals within Australia's aged care system, particularly with this new transition to the Support at Home program. So currently, there are no strict government fee caps for allied health. Providers generally do have discretion to charge for travel and reports, but they must disclose them. From the 1st of November 2025 until mid next year, so June 30, 2026, there's a transition period. And so providers will still set their own prices, but they're expected to be reasonable and transparent with those prices with an eye towards the upcoming caps. And then from the 1st of July 2026, there will be a full implementation of the Support at Home program. And what that means is that government set price caps will apply to allied health services. So all costs, including travel and report writing, must be integrated into that single unit price for the service. So you will not be able to charge separately for travel or reports as distinct line items. The challenge for providers will be to ensure that these essential components of care can be covered within the new cap structure.
Great question. I've got another one coming in just saying, what compliance do I need in my business booking agency sending entertainment into aged care? So a slightly different perspective here. We have somebody who's not necessarily providing aged care services specifically, but is providing a different type of services to aged care residents. So for that reason, you likely won't have to comply with all of the aged care standards that we've discussed above, but the aged care home or other approved provider that is sort of hiring you and bringing you on board to provide these entertainment services, they will enforce and require your assistance to be able to comply with their obligations. So I would expect to see in a contract that they've drafted and provided to you, the kind of things about making sure that the people coming into the home perhaps have those worker screening checks, so police checks, potentially an NDIS worker screening check like Ushna's mentioned. Something you might want to consider is going the extra mile in terms of if you're providing these services sort of exclusively to aged care, and this is a market that you're really trying to target, you can think about how the way that you work can integrate the quality standards. So think about how the service delivery can respect residents' dignity, their choice, and perhaps be quite culturally sensitive to make sure you respect their cultural background. How can you create a space when providing that entertainment that is safe? Your workers are safe and residents are safe, and making sure that your workers are competent, complying with all applicable privacy laws in terms of if they come into contact with someone's personal information. Those are some of the things to consider to make sure that you're providing a great service that, aged care might be willing to bring in and make sure that it is compliant with their obligations as well.
Steph, one of the other questions is what the impact is for dual NDIS registered aged care providers. Yeah, it's going to be challenging. And, you know, there's obviously like you've got to navigate different and complex frameworks. There is a bit to say here, but I'm just conscious of time, so I'll summarize it into 3 points, what the key impacts are really going to look like. You know, obviously that dual regulatory and funding compliance. So you've got to now navigate two quite rapidly evolving and distinct regulatory frameworks. You know, the new Aged Care Act and its associated reforms, like support at home with price caps, and then ongoing NDIS reforms, including pricing arrangements and price limits with new travel rules as well for therapy. Yeah, they often have quite different reporting, quality standards and funding models. So it's going to be, you know, a bit of a job to kind of navigate that. The financial and operational strain as well. So there is changes in pricing, which will necessitate significant reviews of pricing structures, you know, your service delivery model, your admin systems to ensure you're maintaining financial viability, particularly for services involving travel or extensive reporting. And then there's the workforce and administrative side of things. So attracting and retaining staff does become more complex due to the different award rates and training needed across sectors, coupled with the increased administrative load of managing, you know, dual compliance, IT systems and documentation requirements for both NDIS and aged care clients. So yeah, if you are one of those organizations that kind of has to dabble with both, I mean, that's what we're here for. We'd be more than happy to kind of help you navigate that.
Yeah, absolutely. I've got a quite short little statement that I think is actually quite useful to comment on. Someone sort of commented and said, how can I be an advocate of aged care reforms? I think that's a great question. Advocacy often involves education, which is partly why you're here, to make sure that you have all of the tools. Knowledge is power in a lot of ways. So making sure you have all the tools to be able to be an educated voice in your business or amongst workers that you're with, all of those sorts of things to be able to share. Here's what I'm learning about the new standards. And I would say that the really important emphasis is on it being person-centered. That's what we're seeing all across the new guidance, all across the different documentation that is coming our way. Person-centered, person-centered, person-centered. That's what's really coming across as a key message. So often that's one of those things that's nice to say but hard to do. So to be an advocate for those aged care reforms is to think practically, how can we make sure that our organisation and the care that we provide is person-centered?
That's very true, Steph. And just finally, and then we will have run out of time, but somebody's asked what the changes to home care packages will be and the new way providers will be paid. Yeah, so as discussed, there will be a support at home program which will replace the home care packages from November 1st. And the key changes for providers will include price caps from July 1st next year. And so, yeah, while providers are setting their own prices for the first year, the government set price caps will apply to all the services. There is that all-inclusive unit pricing. So separate package management fees will be abolished, and all costs, you know, travel and report writing will need to be built into a single unit. And then increased transparency. So providers will need to publish a detailed price list on their websites and on My Aged Care to enable easier comparison for consumers that are looking around.
Well, fantastic. Thank you so much for all of your questions, and thank you for your attention throughout this webinar. That kind of brings us to the end of our time together today. It's really been wonderful to chat with you, and apologies if we haven't had time to get around to your question. However, as Ushna said, please submit your details in the survey at the end of this webinar, just to make sure that you can claim that complimentary consultation, which is also a space for us to be able to answer any questions that you might have, and also learn a little bit more about LegalVision's membership and how it can help you. So yeah, thank you so much for joining us. It's been wonderful to speak with you, and hopefully we'll see you again soon in one of our consultations or working with you.